Preston Poulter responds to Ethan Van Sciver's motion to dismiss, claims own tweets calling for, quote, the destruction of Comicsgate are only, quote, purported statements and, quote, likely hearsay. Hello, this is Robert Romano with Comicsgate.org. Hit that subscribe button. Today we're going to be talking about the trademark dispute between Ethan Van Sciver and Preston Poulter, who is trying to claim Comicsgate is his trademark, even though Ethan Van Sciver has been using Comicsgate in commerce since the spring and summer of 2018. And Poulter didn't apply for the trademark until April of 2020. And so right now, Poulter has Ethan before the trademark trial and appeal board trying to get Antonio Malpica's old trademark, which has now been assigned to Ethan Van Sciver, canceled. And right now, there's a motion to dismiss that Ethan has put forward via his attorney. And now Preston Poulter has responded to that motion to dismiss and is arguing twofold. The first, that Ethan's attorney didn't properly serve Preston and his attorney with the motion to dismiss, and so they should just not consider it or reject it. But also that the statements that Ethan's motion to dismiss depend on, which includes a lot of tweets from Preston calling for the destruction of Comicsgate, he's saying those are only hearsay, and they're only purported statements. They haven't been authenticated, even though if you look at Preston's Twitter and YouTube accounts, he clearly self-identifies as Preston Poulter. And so I wanted to unpack a lot of this right now. We've set the table there. In addition, the response claimed that Poulter's own suspended applications, which Van Sciver says are void ab initio, or from the start, because Poulter knew Comicsgate was in commerce for years, are, quote, outside the pleadings, and as are tweets by Poulter himself where he calls for, quote, the destruction of Comicsgate, which he claims are, quote, purported statements that are, quote, likely hearsay, that have not been authenticated and therefore are inadmissible at this stage. According to Poulter's response, quote, here the registrant appears to argue that the petitioner has not met these prongs showing standing to sue due to evidence in the public record that is outside the pleadings in this case. Here, however, the purported statements relied upon by the registrant are not only outside the scope of the determination of the legal sufficiency of the complaint, but are likely hearsay as well. So here, Poulter is referring to Ethan Van Sciver's motion to dismiss, where Ethan's attorney, Scott Hudeman, argues that Poulter lacks a bona fide intent to use Comicsgate in commerce. That's a legal requirement in order to put forth an application. According to Ethan and his attorney, quote, the public record, largely a selection of petitioner's own admissions, show Comicsgate is in commercial use years before petitioner filed his own applications. Thus, petitioner is a mere intermeddler, a self-appointed guardian of the trademark register, and has no statutory right to bring this cause of action. And I think that's a legitimate argument to say he has no standing because he has no intention to use Comicsgate in commerce. To the contrary, in November 17, 2019, Preston was tweeting, quote, I am working for the destruction of Comicsgate and would never hire anyone associated. So put your outrage where it belongs. And so this shows what his true intent is with getting the trademark, which is to destroy Comicsgate, which calls into question, how do you intend to use it in commerce? How do you have a bona fide legal intention to use this in commerce if your intention is actually to destroy it? And anyone who was calling themselves Comicsgate prior to him putting forward the application for the trademark. And I think that's something that could, if there's any way you could get TTAB to say that Preston has no standing, this is how you would do it. You would say he doesn't have a bona fide intent, because otherwise, I'm looking at a lot of these cases on motions to dismiss for lack of standing. If you have applications in for a trademark and they've been suspended because somebody else has a registration, that's more than enough to get you into TTAB and to have standing. So if the law is just reading the law and the regulations, Preston should have standing, unless there was a problem with his initial applications that are void ab initio because he actually wanted to destroy Comicsgate. It's a long shot. That what Ethan's doing with the motion to dismiss right now is a long shot, and maybe has a lower percentage chance of success because there's so few motions to dismiss in a cancellation proceeding that actually result in the case being dismissed for lack of standing. This might be one of those, it might not be, but it won't be the end of the world even if the motion to dismiss fails, because again, it's really easy to show standing here. And so, but I wanted to show you a lot of these tweets because there's a question about whether Preston is, withholding information from the trademark trial and appeal board. Scott Hudeman, Ethan's attorney, says, quote, petitioner is flirting with the boundaries of legal ethics with his stubborn refusal to acknowledge authenticity of his social media, prolonging this proceeding in order to force formal authentication procedures when petitioner knows all of the admissions and other exhibits are 100% accurate is to cause unnecessary delay and needlessly increase the cost of litigation in violation of federal rules of civil procedure, Section 11B1. And according to those rules, 11B1, representations in court by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief formed after an inquiry under reasonable circumstances is not presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. So you're forcing an authentication proceeding on something you know to be true. And they also include denials of factual contentions. It has to be warranted by evidence, or if so specifically identified, are reasonably based on a belief or a lack of information. But Preston knows his tweets are real and that that's really him using it. And we know that because he admits on August 19, 2021, I currently have 2 separate legal actions against Ethan Van Sciver, one for libel, one for the Comicsgate trademark. He has filed a motion to dismiss them both, and I am predicting both will fail. His fans talk a big game. Here's another one. Come meet me, Preston Poulter, at Albuquerque Comic-Con, and this was on June 25th, 2021. There's Preston waving at the table. Here's one from May 22, 2021. It's great when I, Preston Poulter, get to meet new fans and discuss my work. Here's another one. Here's a picture of me, Preston Poulter, from the last Albuquerque Comic-Con with actual brothers Daniel and Luis Moncada. That was on May 16, 2021, but I think it was from the year prior, or maybe 2 years prior, Comic-Con over there in Albuquerque. Here's April 23, 2021, less than a week left to support indie comic book creators like me, Preston Poulter, on Kickstarter. Here's one from April 6, 2019. My name is Preston Poulter, and the next comic I am launching will be White Lily #3. In addition, this is Twitter, but if you go to his YouTube video, Preston clearly self-identifies himself. Here's where he launched the idea of getting the Comicsgate trademark and was talking all about it, basically bragging.
The federal government has recognized that I, Preston Poulter, DBA Pocket Jacks Comics, through my corporation Common Sense Press Incorporated, have been granted the trademark of Comicsgate in regards to comic books.
So there you have it. He clearly self-identifies. He's bragging about applying for the trademark. He didn't actually have it yet. So there's a potential deceptive video. He was trying to create public confusion about who owned the Comicsgate trademark at the time, Antonio Malpica. He was trying to get Antonio to abandon his mark. Antonio then revived his mark, and it fully went through registration. He has since assigned it to Ethan Van Sciver. So Ethan's the one defending this mark for comic books right now, but Ethan's attorney, Scott Hudeman, is arguing that actually Ethan's common law trademark predates even Antonio Malpica putting forward this application in September of 2018, which fully registered in July of 2020, saying that this common law trademark, Ethan was using it in the spring of summer of 2018, supersedes Antonio's application. It supersedes Preston Poulter's application, and Ethan was the first one to use Comicsgate in commerce. And so that's what the board should consider, because they should just say that Preston has no right to use Comicsgate, and so you should just dismiss this out of court, because Ethan already has the trademark. Even if the Malpica mark is going to be canceled, it won't matter. In the end, we're going to get to whether Ethan has priority usage, and he does, because he was doing this since 2018. So even if Antonio's old mark gets canceled, what should happen, I think will happen, is Preston Poulter's applications will come up. Ethan will oppose those. He'll say, hey, I've been doing this since 2018. Preston's application is in 2020. Ethan will prove he has priority claim, and then Preston will be refused. And then Ethan's applications would come up eventually, and those would be, I think, granted. And so Ethan's common law trademark will eventually be a full registration. So we think that Preston is probably wasting his time and money and just with this kind of nagging lawsuit. But we'll see how things play out. I think that the rules of civil procedure are interesting here, where he's saying he's not Preston Poulter on his social media to the Trademark Trial and Appeal Board. Factual contentions have to be warranted on the evidence, but clearly they're not. And so Ethan's attorney saying maybe there's a violation of the rules here. There are sanctions under FRCP 11. And sometimes, they could be thousands of dollars, or they could be even millions of dollars, depending on the case. But if you lie in a federal proceeding, you know that those tweets are real. You know that social media account's yours, but you're saying that's hearsay. That's not me. I think that could actually be a big problem for Preston, but we'll see. I think that it's worth bringing up and kind of highlighting. And just what all of these tweets are. It's kind of funny. It's like, oh, don't look here. There's nothing to see here. Right now, he's even offering even money wagers. Quote, this is on August 19, 2021. Even money wagers that Ethan's motion to dismiss will go down in flames. If he's so confident, shouldn't he be offering odds or something? I mean, the odds are, Preston would get standing because he has his applications in. What the question Ethan and his attorney want to have answered right now is whether they're void ab initio. But they might not do that. Might say, no, we have to consider those later. We're going to consider the Malpica mark first, and then if that gets canceled, then we'll consider whether Preston's applications are legitimately filed or not. So you could get a determination now, or it could happen later. Then there's the question of whether Ethan's attorney properly served Preston and Preston's attorney with the motion to dismiss. And so the Preston's attorney is saying, you shouldn't even consider this, or you should reject it because it hasn't been properly served. On the other hand, it's coming. The board has already determined they're going to hear the motion to dismiss. So it could just be that they're going to disregard the service requirement. Ethan's attorney cured the service requirement. He properly served them, albeit after the deadline. We'll see how they rule on that. If they reject the motion to dismiss or don't even consider it, I still think that the standing issues can come to the fore in the trial, because if you don't have a motion to dismiss, you're still going to go to trial, and that might be the most likely outcome. I was looking at some of these cases in Corporación Habanos v. Rodriguez in 2011. TTAB left proof of standing to trial. Quote, in summary, applicant's motion to dismiss the petition to cancel for lack of standing is denied. Petitioners have alleged standing to survive a motion to dismiss, although proof of petitioner's standing is left to trial. And so that might be the most likely outcome with both the motion to dismiss and the response here. This trial is going to go on, potentially, if it doesn't get dismissed right now. And then it could go on for years, and then, maybe it gets canceled, maybe it doesn't, maybe we address standing. I think all of these tweets by Preston Poulter calling for the destruction of Comicsgate, I think those are devastating. I think they prove he really doesn't have a bona fide intent. And there's more communications from him where he's talking about deplatforming YouTube creators who use Comicsgate. It really shows that this is not about using Comicsgate in commerce. It's about using it legally and abusing the legal privilege of a trademark to deplatform creators who have been using Comicsgate in commerce longer than Preston Poulter has. And I'll leave you with the close here. So this might be a potential outcome where standing is going to be determined at the trial, not on the motion to dismiss, but once we get to discovery and those fun things. This might be a potential outcome to watch out for. And since proof of standing could be left to trial and has been in the past, perhaps Poulter is anxious to have this settled right now on a procedural basis, like failure to properly serve, rather than on the merits, since it will be easily proven that Poulter owns and operates his social media accounts, where like a Bond villain, he makes elaborate speeches outlining all of his devious plans for, quote, the destruction of Comicsgate. Again, we'll see. Anything could happen. Stay tuned. That's the commentary. This is Robert Romano with Comicsgate.org. Hit that subscribe button, ring the bell for notifications, and have a good evening.